Ready, start. The respondents were governed by the fundamental statutory rules as per the order dated 12/11/1997 of the competent authority, which aspect is further fortified in light of the decision dated 29/11/1997, which extends the benefit of retirement benefits etc. to the scheme employees, restricting it only to the management of finances under the scheme itself. Full stop. This court, while its earlier judgment in the case of Vinod Kumar Goyal within bracket Supra bracket close has dealt with this aspect and has categorically held that the employees appointed under the scheme would be governed by the rules as applicable to the government employees as per the conscious decision of the government. Full stop. The employees were also entitled to continue till 60 years of age, further entitling them to consequential benefits, which is apparent from the subsequent order dated 10/7/2014 passed by this court in the second round when Vinod Kumar Goyal was not granted the benefit of pension by the government. Full stop. Dealing with the distinction which is being sought to be pleaded by the appellant with reference to the non-applicability of the judgment passed by this court in the case of Vinod Kumar Goyal within bracket Supra bracket close is that he was an employee of the state of Uttarakhand with state of Uttar Pradesh not being a party thereto. The said judgment would not be binding upon the state. Full stop. This plea of the appellant, at the first blush, may appear to be attractive, but the fact is that at the time of appointment, under the scheme till the year 2000, when the state of Uttarakhand was carved out of the state of Uttar Pradesh, he continued to be governed by the rules and regulations framed by the state of Uttar Pradesh. Full stop. There has been no changes brought about by the state of Uttarakhand in the said rules slash regulations, other than as has been taken by the state of Uttar Pradesh. Full stop. The decision, therefore, of this court in Vinod Kumar Goyal's case, along with the principles laid down therein, would be applicable to the present case. Full stop. Principle of estoppel, acquiescence and waiver as sought to be pressed into service by the appellants for the reason that the amount had been withdrawn of the contributory provident fund by the respondents, again, would not be of any benefit to the appellant as the respondents had no option but to resort to the same. Full stop. It is apparent that the respondents had at the very outset put forth their claim for pension, which was declined by the appellants, and that too either prior to retirement or prior to withdrawal of the fund under contributory provident fund scheme. Full stop. They were always and are still ready and willing to deposit the amount withdrawn as is required to be so contributed, therefore, the principles as sought to be pushed into service is without any basis. Full stop. The submission of the learned senior counsel for the appellant that switch over from one scheme to the other scheme is not permissible under the rules for which reference has been made and reliance placed on the judgment in Rajasthan Rajya Vidyut Nigam Limited versus Dwarka Prasad Kulwal and others, would be of no avail on facts. Full stop. When seen, this was a case where an option was given to the employee to switch over from the contributory provident fund scheme to the pension scheme, which option had not been exercised by him. Thus, the said employee was held not entitled to the benefit of the pension scheme. Full stop. Similarly, reliance placed on the judgment in Union of India and others versus MK Sarkar, would also be of any benefit as it was held that when given a chance to change of option by the employee, if not exercised, would disentitle the employee for the claim. Full stop. These judgments are thus distinguishable both on facts and the issues involved herein, full stop. In the present case, comma, there was no option given for switch over to the respondents. Rather, it was asserted that they were not entitled to pension which, comma, as held above, comma, has been found to be unsustainable, full stop. There has been claims for pension etc put forth by them within reasonable time, full stop. As regards the objection of the appellants with regard to the delay on the part of the respondents in approaching the court based on reliance placed on the judgments in UP Jal Nigam and another versus Jaswant Singh and another and Sarv Shramik Sangh versus Indian Oil Corporation Limited and others is concerned, those would not be of much help since in those cases, comma, the claims were put forth after an inordinate unexplained delay, comma, whereas in the present case, comma, the respondents had either retired subsequent to the date of decision while others had approached the High Court and obtained interim benefit of continuing in service till the age of 60 years. Full stop. This court in various judgments has clearly held and settled that pension is not a charity, comma, or a bounty, comma, and an employee is entitled to receive his pension. Full stop. As a matter of principle, comma, belated service related claims need to be rejected on the ground of delay and laches. Full stop.